Hi, I am Dr. M. Prakash, Associate Professor, Department of Commerce, PA and IT, Kamadin Arts and Science College, Satyamagalam. Today, we are going to discuss about the comparison of Companies Act 2013 to 1956 Act. First of all, we see the introduction. The Companies Act is the backbone of corporate governance in India. The principles of regulations of the formation, management and dissolution of companies in India were laid down by the Companies Act 1956. Time went by and it was felt that due to the ever-changing complexity of business and now new market practices and economic integration worldwide, this law had to be changed. The Arabic 1956 Act was replaced with the enactment of the Companies Act 2013, which brought into the take place and significant reforms to achieve better governance, transparency and accountability also. Then the meaning. The Companies Act refers to the legal framework through which companies are incorporated, regulated and dissolved in India. The Companies Act 1956 was the primary statute that laid the basic structure of company law in India, regulating all kinds of aspects such as the formation of company, corporate governance, accounting standards and the rights of the shareholders. Over the time, with the changes in the business environment, the need for more robust corporate governance, the Companies Act 2013 was introduced and it replaced the 1956, the law to improve transparency, accountability and compliance in corporate practices. And it brought May reforms to modernize Indian corporate laws, bringing them to par with international standards and addressing issues of governance, shareholders' rights and financial transparency. The Companies Act 1956 and the Companies Act 2013 present two key points of departure in India's history with the corporate law. Although the former laid down a base to govern companies, and the latter presented many of its new age reforms concerning current day challenges of companies in this respect. Most fundamentally, differences between the two indicate an enhanced necessity to seek higher corporate governance and responsibility in accordance with the modern and contemporary international norms and requirements. Let us now discuss the major differences between the Companies Act 1956 and the Companies Act 2013. First difference is the number of sections. In 1956 Act, the Companies Act 1956 consisted of 658 sections and spread over 13 parts with 15 schedules. But the present Act 2013 is concise in nature with only 470 sections and is divided in 29 chapters and 7 schedules. The number of sections has been reduced for the sake of simplicity of structure. And second, the corporate governance. In 1956 Act, it has a fewer provisions on corporate governance, which resulted in more loopholes in the aspect of board accountability. So that the 2013 Act, it has provided strict norms on corporate governance, including independent directors, audit committees, and the disclosures that are mandatory in order to increase transparency. The very important one-person company. In 1956 Act, there is no detail about the one-person company. But in the case of 2013 Act, is introduced the concept of a one-person company, simply called OPC, allowing individual to start company with a single shareholder, promoting entrepreneurship. The one-person company also motivate the individual to establish a business or to establish the entrepreneurship. It is very helpful to the government in the case of more number of entrepreneurship started by the individual people. Then fourth one, the financial year. In the 1956 Act, companies were allowed to choose any financial year, provided it was for the period but not exceeding 15 months. But in the case of 2013 Act, stipulated that all companies need to have the same financial year, which would extend from the 1st April to the 31st March. Then sixth, corporate social responsibility. There is no regulations were made related to the term corporate social responsibility in the 1956 Companies Act. On 2013 Act, it is a mandatory CSR, the corporate social responsibility of the company with net worth exceeding 500 crores or has turnover over 1000 crores or its net profit also in excess of rupees 5 crores. Then sixth, the board constituent and meetings. In 1956 Act, it made it very easy for companies to have flexibility with regard to board composition and did not impose independent directors for private companies. But in the 2013 Act, this Act demanded that particular categories of companies should comprise specific number of independent directors and placed severe constraints regarding the functioning of board meetings and minimum number of participation in the board meetings also. The seventh one is the appointment and the rotation of auditors. In 1956 Act, the auditors reappointment is possible under the Act but without mandatory rotation of auditors. In 2013 Act, introduced changing auditor every 5 years to avoid collusion and gain independence. It is the very important one. And eighth one, the class action suits. In 1956 Act, it did not provide for class action suits, no details. But in the 2013 Act, is provided for class action suits. It is an action by shareholders and depositors against a company on grounds of malpractice or fraudulent practices. It brings accountability into the system. The ninth difference is mergers and acquisitions. 1956 Act, the merger and acquisition procedure was a long process. It have and it's requiring various regulatory approvals from the various authorities. But 2013 Act, the mergers the very easier to achieve and less comparison in small scale companies and between holding and subsidiary companies, needing fewer sanctions. The 10th one, electronic filing and documentation. In 1956, most documents and presentation were done through physical writing and manual work. But the 2013 Act, it promoted the electronic presentation and record maintenance of accounts. This is the digitalization paved the way for a very efficient process of management economy. And the quicker decision is possible in the case of electronic filing and documentation. The 11th, the penalties and enforcement. In 1956 Act, its action given to such non-compliance companies were soft. This provided them ample the opportunities to deviate without having to worry about the sustainable punishment. But 2013 Act, strict measures against violation of corporate law. In some cases, an offence might be punishable even by imprisonment. The 12th, National Company Law Tribunal, NCLT. 1956 Act, company law cases were dealt with by the high courts and part of the regulatory decision had been vested in the company law board only. But in 2013 Act, the NCLT and the NCLAT are the specialized tribunals created specifically to tackle the corporate disputes as well as the governance matters effectively. So, in this case, definitely we don't spend more time to discuss and dispute any problems from the company. And the conclusion, The Companies Act 1956 gave way to the Companies Act 2013. Exactly. And which makes a step into modernization of the corporate law framework of India. In the new act, a number of reforms have been brought forth to bring out the more transparency, accountability, and corporate governance, which simplified the business processes. These were some of the landmark novelties in the 2013 Act. It's mandatory CSR, independent directors, auditor rotation, under the action claims also. All of them are new closer to the standards followed worldwide in the corporate sector. In addition to the specialized tribunals, for example NCLT, they enable executes the resolution of disputes. Thank you.